Getting a divorce in Oklahoma is actually simpler than you might think. Either spouse must be a resident of Oklahoma for 6 months before filing for divorce. The divorce may be filed in the plaintiff's county of residence if the plaintiff is a resident for more than 30 days or in the defendant's residing county. Once the residency requirement is completed, a legal grounds for a divorce must be established. Both general and no-fault divorce are acceptable grounds for divorce. The no-fault reason is incompatibility. The general reasons for divorce are impotence, adultery, abandonment for 1 year, imprisonment, confinement for incurable insanity for 5 years, cruel and inhuman treatment, fraud, habitual intemperance, drunkenness, the wife pregnant by another at the time of marriage, gross neglect, and a foreign divorce which is not valid in Oklahoma. Oklahoma does not require a parenting plan for child custody. Joint or sole child custody may be awarded based on the best interests of the child and the preference of the child if the child is old enough to form an intelligent preference. When it is in the best interest of the child, the court shall assure that children have frequent and continuing contact with both parents and encourage the parents to share the rights and responsibilities of child rearing. However, there is no preference for either joint or sole custody. The court considers which parent is likely to allow frequent contact with the other parent. There is no preference for either private, public, or homeschooling of children. Sex of the parent is not considered. Not allowing visitation may be considered against the best interest of the child. The court may require that the parent submit a joint custody plan to the court if joint custody is desired. The parent awarded custody of the child must provide for the education and support of the child to the best of his or her ability. If inadequate, the non-custodial parent must assist to the best of his or her ability. A portion of the non-custodial parent's property may be set aside for the use in supporting the child. The only factors in the statute are the income and means of the parents and the property and assets of the parents. There are official child support guidelines and compilation forms in the statute, and forms are provided by the Oklahoma Department of Human Services, available from any court clerk. The amount of support according to the guidelines is presumed correct unless it is unjust, unreasonable, inappropriate, or inequitable under the circumstances. Payments may be made through the court clerk. Security or bond may be required for the payments, and income withholding may be used as a guarantee. Oklahoma is an equitable distribution state. Each spouse is entitled to the property owned by him or her before the marriage and any gifts or inheritances acquired during the marriage. All property held or acquired jointly will be divided in a just and reasonable manner. A portion of that property may be set aside for one spouse to support any children living with that spouse. The only considerations in the statute are the way in which the property in question was held and the time and manner of the acquisition of the property. An automatic injunction against disposing or damaging property or altering any insurance policy goes into effect as of the first court hearing. Marital fault is not a factor. Alimony may be awarded to either spouse. The award may be monetary or property, in lump sum or installments, depending on the value of the property at the time of the award. Marital fault is not a consideration. There are no other considerations in the statute. Alimony may require payment through the court clerk. The court may appoint an arbitrator for joint custody disputes which take place after a divorce. Visit us today at www.mydivorcepapers.com and click on Oklahoma at the bottom of the page. Let mydivorcepapers.com help you file for divorce today.